If your I-751 gets denied, you don't just lose your green card. You could end up in an immigration courtroom facing deportation and paying a lawyer $10,000 just to fight for what should have been an easy approval. So stay with me for the next few minutes, because I'm going to make sure that never happens to you. So, I've been receiving lots of questions about the I-751. In the current environment, there is a lot of anxiety in the air. So, this video will answer many of your most common questions, and I'm going to try, in a short 5 to 10 minute video, to cover everything I believe most people need to understand about the I-751, so their case can be approved successfully, so they can fully remove the conditions from their permanent residency. And when I'm referring to the I-751 here, there are actually two different situations in which an I-751 may be filed. What I'm discussing is how conditions are removed after marrying a U.S. citizen. If someone marries a U.S. citizen and becomes a permanent resident within 2 years of the wedding date, or if the I-485 is approved within that same 2-year period, then the residency is conditional. When they receive their green card, it will simply be a 2-year card, and you must file Form I-751 to lift the conditions on that card before it expires, specifically within the 90-day filing window before expiration, to be precise and on time for sure. The only time you can submit it earlier is if you divorce, which I'll discuss near the end of this video in a separate section. And for people who are separated or going through divorce, please know that success in that case is still achievable as long as you have proof the marriage was entered in good faith. So, one question people keep asking me is whether I should file evidence from our entire relationship or only from the 2-year period when I was a conditional resident to support the case later on. And generally, it should only be during that 2-year window. However, it really does depend. I would recommend submitting any evidence that was not previously included with your adjustment of status application, even if it comes from before the date you became a permanent resident. But if you carefully read the I-751 instructions, they specifically ask for evidence from when you became a permanent resident until the date you filed the I-751 in that period. And once you file the I-751, let's say you submit it during the 90-day window because you are still in a bona fide marriage, I would keep saving proof of that bona fide marriage, since the process of removing conditions can take more than a year, sometimes more than 2 years. And if you get a request for evidence, say a year and a half later, you want to be ready with additional evidence to submit at that point in response. Also important to know is that once you file the I-751 based on marriage to a U.S. citizen, 1 year later, even if the I-751 is still pending, you may file your N-400 application to become a U.S. citizen as well. And what that often does is make USCIS combine the I-751 and N-400 naturalization applications and hold one joint interview for both cases, where your U.S. citizen spouse would also need to attend if you are filing based on continuing in a good faith marriage in person on that interview day. During those interviews, the first portion is the I-751, where the officer will speak with you and your spouse together in person. And after that, they'll move on to the N-400 application and administer the citizenship exam then. I'm not going to go too deeply into the N-400 process in this video, but just know that it will be combined. And in this situation, your U.S. citizen spouse absolutely has to attend the interview if you file it jointly with your spouse there. Conversely, if you choose not to file the N-400, or if the I-751 is decided before you get a chance to file the N-400, it is fairly common for it to be approved without an interview. Not always, but in my experience, when people submit strong evidence, it usually gets approved without a later interview afterwards. So, when you receive your conditional resident card, the card that expires in 2 years, you are a permanent resident. You have all the rights and privileges of permanent residents. You can travel like a permanent resident. You can work in the U.S. like a permanent resident. You can even petition for certain family members just like a permanent resident. However, if you do not file the I-751 to remove the conditions, you will likely receive a notice to appear in immigration court, where USCIS may claim that your permanent residency ended because the I-751 was not filed. Whether that is actually true is open to debate. I would argue that it is not true until an immigration judge agrees and orders removal. Under the Immigration and Nationality Act, there are only two ways to actually lose residency. One is a removal order from an immigration judge, and the other is filing and signing Form I-407, a voluntary abandonment of your permanent residency status. Another question I often get in the comments on my other videos is whether we need to submit bank statements every month, or whether once per quarter is enough. And the answer is to submit them for every single month, always. Overwhelm them with proof. If your packet is hundreds of pages, you are doing a solid job. Do not assume once per quarter is enough, or a couple of photos is enough, because you are in a good faith marriage. I have seen these I-751 cases get denied because people took it too lightly and were completely in a good faith marriage. But then they had to pay a lawyer $10,000 to defend them in removal proceedings. It is absolutely possible. The case is winnable, but it is costly now, and it was definitely avoidable. So, submit all available evidence now. Flood them with financial records, trip records, joint credit card records, joint insurance records, joint tax returns, and all that helpful documentation as well. Treat it as if they know nothing about you. Do not assume they have already reviewed your previous applications. Assume they know nothing. Another question many people have been asking is, what about criminal history, traffic violations, citations, or even a DUI? Could that affect my I-751 process in any meaningful way at all, really? And the answer is usually no. Unless you committed a crime that actually makes you deportable, and in most U.S. jurisdictions a DUI is not viewed as a crime involving moral turpitude under the law. But speaking from what I have seen, they do not review your criminal history for the I-751. The officer has one task. Is this marriage truly bona fide? Do they continue living in a bona fide marriage? Or if it is based on divorce, was the marriage originally entered into in good faith? They're not checking criminal history. In fact, the I-751 does not even allow disclosure of criminal history at all. So, do not worry about that overall. Just focus on showing that your marriage was entered in good faith. And before I move to the next section, I just want to say that if you are stressed about the I-751 or any family-based immigration, I handle permanent residence applications, adjustment of status, consular processing. I-751s are a part of our work, and naturalization, which is applying for citizenship. So, if you need help with any of these matters, you can find my information to schedule a consultation in the description below for details. All right then. So, what happens if you become separated or divorced during your 2-year conditional residence process? Well, the riskiest situation is getting separated and staying separated without taking any further action to resolve it, not trying to repair the marriage, not trying to divorce, and instead staying in limbo while hoping your U.S. citizen spouse will sign the I-751 with you, which has to be filed jointly if you are still married at that point in time. That is a risky situation for a number of reasons there. What if they refuse to sign with you? What if they sign it and then become upset with you and try to withdraw their signature, which they are able to do? And if they do that, you will likely receive a notice of intent to deny by mail, giving you 30 days to file a new I-751 under a different category there. I have seen this happen to many people before. My advice is, if you are sure the marriage cannot be saved, then get divorced as quickly as possible. Sometimes it may be a good idea, if you are on good terms, to file jointly before you begin the divorce process. Sometimes it depends on whether it is a good faith marriage and whether we can make the argument honestly. Sometimes it is a good idea to do that just to buy some time, because if you file your I-751 by yourself, even though you are still legally married, then that can create major problems, especially if you have not yet filed for divorce. So, there are some scenarios where, 3 months before the green card expires, right in the I-751 filing window, some marriages suddenly completely fall apart from there. And that is actually the most stressful situation to be in because for the I-751 to be approved, you either need to be fully married or fully divorced with a divorce decree. And obtaining a final divorce certificate is not a fast process in some jurisdictions. There are even some states that require you to be separated for a while before you can even file for divorce there. And those are the most stressful cases overall. So, what we often do in these situations is file the I-751 based on divorce, even if you are not fully legally divorced yet, and we include a copy of the divorce petition showing the divorce is pending. This will usually buy you a little bit of time, but USCIS can issue a request for evidence fairly quickly, giving you only 87 days to submit proof that the divorce is finalized. Hopefully, they will not issue the request for evidence for several months. So, you will have a couple months plus those 87 days in perfect scenario. And hopefully by then your divorce is finalized, because if you reach the end of the 87-day period and the divorce is not finalized, you risk the I-751 being denied and you being placed into removal proceedings later on. In some rare situations, it may even help in that scenario to file a new I-751 or change the category of your I-751 before it is denied by showing that your removal from the U.S. would create extreme hardship for you. I do not like that. I think it makes the case messy, but there are some situations in certain jurisdictions where that may be advisable, especially under the current NTA policies USCIS uses today. All right, everyone, so this is the end of today's video for now. If you got any value from this at all, the big favor I am asking of you is simply to give the video a thumbs up here. Or if you want me to discuss other things and you did not like the video, give it a thumbs down, then go into the comments and tell me what topics you want me to cover. My staff will go through all the topics and create a list for me that I will choose from next time I make videos, and I will respond myself, saying that is a good suggestion. I'll cover that in a video next week. If you're new to the channel and want to stay up to date on all the immigration changes under the Trump administration, be sure to subscribe. I try to bring you up-to-date content, and I will see you next time for another video.